To today's section. So today I'm going to run through the subclass 4914 and 494. Just before we go forward, okay, so everything contains in this information might have changed according to the new policy, because we got instrument and we got regulation that complies with this legislation, but we haven't got detailed policy yet. I have of course print out the fact sheet and then provide it to everyone so you can have a look. Basically, the new subclass 491 and 494, before we actually dive in this subclass, we have to understand the intention of the government. What's going on here? Why they abolish visas and then why they change visas? What's going on with 189? It was really popular. What's going on with 457? So before we say what is going on, why do they now need to new workers? All right, what's going on? Is that going to be harder or is it going to be easier? Is that the next move? Now I have to tell you that I have myself spent a great period of time to investigate. I mean, reading the parliamentary report to see what is the next move and what's going on. So my understanding is the immigration, so Australian immigration will be for the next move, which we will see a lot of skilled workers coming to Australia. And they will introduce more visas, okay? They will introduce more visas. So for this 491494, this type of visa, these two type of visa, it's actually replacement of a previous visa. Okay, the price of 187 and 487. 187 has been really unsuccessful at all. Because for 187 visa, we have to go 3 stages, namely RCB, nomination and visa application. That's the thing, RCB people who are not working, with the department or with the federal government or the city council, they actually working, they are the business commerce person, right? They just read documents, they have no expertise in any sort of thing. They just check them, it's really easygoing person. And then their entire life, to be honest with you, I just feel their entire life it's just sitting there and checking the documents. Of course, you can argue that the case officer, they do the same thing. But because of this really easy to go, in order to approve the visa, the government, the department has to approve a final stage, right? Has to approve a final stage. And then they realize what RCB can be easily get approved. Then on the nomination, they just don't know what to do. Do they want to refuse or do they want to approve the nomination? Because if they refuse the nomination, is that mean that they refuse that RCB people's certificate, right? So it's hanging on at 187. Since the first introduction went well for first year, and then after that it went downside. 187 being, you can sit there for 2 years, and then they just don't know what to do. The reason they don't touch it or they don't allocate case officer to look at the 187 because they had the intention in mind they're going to abolish this one. By abolishing this, we will introduce a new system, which 494 announce another government body, which is state government, to have that processed in a state business and skill migration team. So this power will be moved back from business commerce, from the regional council, moved back to state government. They will have the power to, because they have knowledge about business visa, isn't it? State skill nomination type of visa. So the difference between 494 and 187, it is that 187 you have to wait for. So 187 is a permanent visa, but that's a visa condition. You must work for the same employer in the same location for 2 years. Okay, if you run out 2 years, then that's fine. If you cease work with the same employer, within that 2 years, they can cancel the visa. For 494, you need to wait 3 years. So it's 494. It's a temporary visa. It's not permanent visa. You have to work. The visa itself will be granted for 5 years, but you must work for the same employer on the same location for 3 years in order to get PR. All right. So this means that it's going to be harder. No, I don't think so. because we will see more legit applications being put through department, which means they will process sooner. All right, and they are unlikely to reject because they don't have a human resource to look at this. Oh, is this one, it's genuine application or not? You have to spend a lot of time to think about, am I going to refuse? And to be honest with you, writing a refusal letter is really time consuming. You have to justify, you have to quote legislation. You don't want to pick up by the manager, say, oh, you got wrong with the legislation. So my understanding with the department, the case officer, is that refusing a visa take greater amount of time. So if they decide to refuse visa, you can see that they take a long time. Our work. When you need to write submission, you just wait until the end of the day, and then you're not going to write it. Okay, so you wait the next day. If you want to approve someone's visa, it's really quick. So we'll be expecting this 494. The visa will be processed very fast, just like 482, 3 to 6 months. They want to, if you're genuine, this is in the place, and then they will approve the visa. Of course, who can determine whether there is a position needed for this business? The current case, it's business they provide them to sales. They say, I need it. Okay, I've got 2 job ads here and run for 4 weeks. And couldn't find anyone. Oh, that's my statement. I self-claim it. This is current procedure. Of course, that will be changed. I just remind you that will be changed. This will later not determined by the employer themselves. It might be the case that Department of Education, Department of Trade or some other government body, they will assess whether the company needs this position or not, and the fee for that one might be free. I might be a small part of charge, but this is not a bad thing at all, because this allow them to check if they can go on first stage. If they can pass the first stage, they don't need to worry about nomination got refused and I can't get the staff refund. So this is the intention, and that will be introduced into the new 494, and then we'll then implement to 482 as well. Now for 491, we will replace 489. Okay, and you will see that 189 skill migration, it was gradually abolished. Okay, it will gradually abolish. This is I have been talking about this constantly, that because this type of people, when they enter Australia, they could not get job. They could not secure a job in Australia, and they bring kids, they bring whole family, and they just rely on government for benefits. This is not going to be beneficial. And the parliament and the committees, they have seen these issues 5 years ago and read that as well. So these people percentage really high. Skill migration, they came from different country. They have had to work really hard in order to earn a living. Then they enter Australia. Oh, you don't need to work. And then because of the language barrier, because of they don't have that connection and they don't have the confidence, they feel, oh, should I just ask for free help? You know about this Apple story. If you give someone an apple, and then later on you take back the apple, they just blame you why you could not give them a second one. The first one will be the benefit to them, right? So for 491, because this is a skill work type of visa, that person must work for that regional county place for 3 years in order to get PR. So therefore, they have an initiative. They say, oh, I must work, otherwise I can't get my permanent resident, and my visa will be running out in 5 years' time. I need to, get myself ready, dress up, and go to interview, right? I need to do something. So 189 will be gradually abolished. Therefore, your marketing should be aimed on regional area. You should go push everyone into regional. Now, regional one, I have a table later on for a guidance only. They will change a lot, but the definition of regional will be broadened. It will allow these people to not just go to the CBD area, but other regional area as well. Now, in terms of 49491, this is skilled visa. Sorry, I've got some Chinese characters here. This type of visa has 5 years. You will need to 191. It's a permanent visa. After 3 years, you can apply for PR after 3 years. The visa holder can move one area interstate. They can move one area to the other area, but they must be within that definition of regional. In order to get the points, they will of course seek for 65 points for at moment. If their occupation is on that state occupation list, they'll be scored 15 points. And if their family living in that regional area, then they got 15 points as well. So this is really beneficial. I will give you a table later on to say who it can be identified or, as your family. The STEM qualification, STEM represent science, technology, engineering, and mathematics. If your clients hold one of the qualifications, then they will be awarded for 10 points, which is awesome. They want engineering because mining is coming back. Okay, mining in Australia is coming back. We see a lot of change here. If the main applicant has a skilled partner, meaning that the wife has or husband or girlfriend, boyfriend, their occupations on the skill occupation list and obtain a positive skill assessment, then they can be awarded for 10 points. Interestingly, which is really fair now, a single person can be awarded for 10 points. So we are not sure at this moment what evidence need to prove that you're the single. What happened if someone claim I'm single and then they get married after they got PR of 491? How do you do this? So you can't really prevent anyone to get married, right? So they just say I'm single now. So can I add my wife later? Something like that. But if you already married, you have a marriage certificate for later on. If you want to add a wife, you claim a single, that's fraudulent documents, right? So you can't really say that. Okay, single, because the intention of the department that they don't want to put the disadvantage of someone just being single, right? So they have 10 points for if you have a partner that she or he can score IELTS 6, even they don't have a skill occupation or they could not obtain positive skill assessment, then they can be awarded for 5 points as well. So additional points, you can see additional points. That's no way 189 will be got it at this time of points, right? Stay nomination 15 points plus a single person 25 points. And STEM, you're going to score 85 or 90 points on the 491 and no. So you can see that why this type of visa, they will increase the allocation secretly. Of course, they don't want to tell you because everybody going to just, let's manipulate this system again. So this is really good to see that if you've been doing 489, this will be pretty much your same client base, okay? Same client base, and they are highly skilled, their occupation. But of course, we need to check occupation list now. I just need to let you know that Queensland they have been negotiating more points. More invitations this year. They've already secured more points. So, of course, because I'm in Brisbane, so I encourage everyone come here. Please, if you have a skill, come to Brisbane or Queensland, okay? We have more in EOIs this year. So relative in immigration. The definition of relative is broader because it includes grandparents, mother, father, your brother, sister, step, or adoptive brother, sister, siblings. De facto, you don't want to mention that because if you're de facto, then pretty much means that person you can nominate under family type of visas. Okay, so the relative can be your child, stepchild, grandchild, step grandchild, niece, nephew. They can be step adoptive, first cousin, aunt, uncle. They can be step aunt or adoptive aunt. So the relative can be you as an applicant, your relative, or your partner's relative. It can be either way. So it's fine. You're going to get 15 points on that one. Okay. The difference between, I suppose actually to compare the difference between 489 and 489 and 494. Sorry, I just confused this subclass. But I want to compare these two because it shows that the development of our work type of visas. So for 482, though no skill it's required, unless you are tradie and that your occupation is on the TRA occupation list. Generally speaking, you don't need a skill assessment, okay, unless that your occupation is tradie and on the occupation list, and then in certain country, right? For 494, that's no exception. You must do the skill assessment. And I actually got so many news on someone or migration agent or whatever in Australia. They ask people to just, hey, lodge 187 now because they're going to close this one. Don't lodge it. Nobody going to approve this for 187 anymore. Okay, just as simple as that. They have got a new team working on different type of visa already. 187 is never going to approved. So I don't understand that why they're doing this is not beneficial for the clients. You can't just say just lodge this one because you just lodge this one. 187, I haven't been seeing a lot of 187 being granted because they don't process it. All right, they wait there for 1 year, 2 years. Nobody is looking at the file. All right, so why are you pushing the clients? Because we have better subclass, although they do need skill assessment, but then you just need IELTS 6, and then this is requirement for 187 as well. And then possibly that client can stay not in Seoul regional area. So I really don't understand this. We should not push a client for 187. Although it's closing just let it close. Okay, we have better subclasses ready for client. So years of experience for 487, we require 2 years. If the occupation is on a short occupation list, we require, so the visa will be granted, so 2 years if this is on a short occupation list. If the occupation is medium occupation list, then the year will be granted for 4 years. For 494, sorry, just find it really difficult to pronounce it. 494, it will be granted for 5 years. Okay, so PR option for 482, it's 3 years as well, right? There's no difference. So for age 482, for normal 482, the age requirement is 45, unless there is always exception, right? Always exception for labor agreement. For nursing, for some company specific, nursing could be a really good one. And they increase that to 55 years old. That's the maximum age. But for 494, there is particular waiver that's clause. I haven't seen that explanation or what it can be waived. But I think there'll be broader options. Previous one, we have a waiver for high skilled or something like that. I think that will be a lot of add-on on that waiver. So work experience for 482, we need 2. For 494, we need 3 years. For 4982, you can be in or Australia, you can be nominated under TSS. For 494, it has to be designated area. So what is the designated area? I'm just giving you a really good example of 2016 and 2012. That the department will use this as a reference. You will see that a lot of areas are included in this area. So we'll be seeing a broader definition of the designated area, which is previously we called regional, now we call designated area, right? So pretty much everywhere exclude the CBD area, right? So the invitation ranking. For the skill one, for invitation ranking, they rank different according to the preference, according whether these occupations are highly demanded. If two candidates, they pick the same occupation and they have similar situation, for first order they'll be picked they have a skill spouse or they are single. All right. So if you're single, they will say, oh, you're not going to get married, you're not going to get kid very soon. So, well, you can work for another 5 years, pay the tax. You don't need to claim housing benefits, something like that. But if you have a skilled partner, right? You're highly skilled, your partner is really highly skilled, it's unlikely they're going to stay at home, really, isn't it? This is, I'm sorry, but they are really practical in this case. They don't want someone to come here sitting at home and raising 5 kids while asking for help from the government. And why, does the government need to support you in that regard? The second order is that if you have a partner that the IELTS can score 6, which pretty much is the case, as statistics show the same. If someone can speak English, good English, they are highly educated, they are easy to get job, because not probably about whether they are competent in their industry. It's really about they are not that confident to go out seek job, to go out to get job interview. They might be reluctant to just go do something for that. So it does make sense. Third order, if you have a partner, but the partner, your wife or husband, doesn't have English at all, could not get IELTS 6, which is really easy to get for, I don't know, for some applicants. If you can't really read and write, then that will be an issue. And the third order, it will be unlikely pick up by the EOI. And then get invited. This order makes sense as well, because you get points based on you are single. All right. So if you have if your partner has no English, no skill assessment, then you have no points. Now we provide provisions for self-refund. It had been discussed that for a 2 is really unreasonable. That someone just lodged sponsorship, got approved it, and then the lodge nomination, bang, they got nomination refused, and that person never started working, and then you can't get a refund. So what is the point? It's really terrible policy. And then investors, business owners, employers, they are really someone behind the lobby group. They want to, hey, I'm going to hire these overseas people. I have to pay that. I've got nothing. What's going on? So they're going to implement this. They will provide a clause for self-refund. Clause including if the sponsorship was refused or withdrawn, and nomination is pending. So there will be no sponsorship approval. Therefore, nomination will be refused. So all you need to do is just write to them, hey, I'm going to withdraw my nomination. They will get the self-refund. Nomination fee will not be refunded, but self will be refunded. If they withdraw the nomination, you'll be for the purpose of that's wrong labor agreement or wrong occupation, wrong stream, wrong calculation, something like that. They got it wrong. And or if the client, employees, they cease to work within 1 year. So basically, want to protect the employer now, right? They are Australian employers, so you really can't just ask someone to lodge and then get money and then never refund them. So what is the point of this visa at all? No one want to come here, right? So when the applicants can start to work, that if they're outside Australia, they should start work after 90 days after their first arrival. And if they are in Australia, then the date is 90 days after visa approval. So just to give you some examples of a previous year, the statistics showing that the first top visa grant, the first occupation is actually developer programmer. This actually indicates something, that if you nominate something else, if you nominate as a developer programmer, your visa will be highly likely to be approved, isn't it? So not because only developer programmer this occupation were nominated. This is not the case. It's the case that they approve this occupation more frequently than others, right? So first 2 is about ICT, then cook, Cook is always very popular, so they will not remove. And then lecture. Okay. So for top 3 citizenship countries for this type of visa, 457. I'm saying 457. The top one it's India, because they are lost. So it's just telling the truth as well, because India, they all come with IT background. UK, of course, and Philippines. They come to work as a nurse. So that's their occupation. Alright, so this is end of this section. If you have any questions, you can comment below or subscribe my channel. Thank you. Bye bye.